The trial for Jennifer Crumbley started today with jury selection. Jennifer and her husband James are both now charged with 4 counts of involuntary manslaughter. Their son shot and killed 4 students at Oxford High School in 2021.
There's a pool of 300 potential jurors. Attorneys will select 12 plus 5 alternates. Meanwhile, there is still question as to whether the shooter himself will be called to testify in either of his parents' trials, with his attorney saying that he's advising him to remain silent.
This is all just starting, but joining us to break down today's proceedings is defense attorney Terry Johnson. Thank you for being here.
Thank you.
Also here with us, former federal prosecutor Rick Commentero. Thank you also for being here.
Thank you.
You both were with us as we started the Miller hearing process. Now we are moving forward with the parents. Terry, I'll start with you. How do you feel that things will go with James and Jennifer?
I think it's going to be an emotional trial. I've said all along, even during the Miller hearing, as it relates to the parents, I think these are the wrong charges. I don't think that you can effectively get involuntary manslaughter, but I think the community is going to convict on something, and that's the only thing in front of them. So unfortunately, in my opinion, they'll be found guilty.
Well, when it comes to those charges, for a school shooting, these are unprecedented. What do you think, Rick, is going to become of that? The fact that this is kind of uncharted territory, how will that affect the trial?
I think the trial will be tried in the typical involuntary manslaughter method by the prosecution. They'll have to prove each element beyond a reasonable doubt. I agree with my esteemed colleague. I think that these are the right charges, the involuntary. I think if there's any case in the United States where these charges could be brought for this particular fact pattern, I think this is the right one at the right time. So I also agree that I think this will result in a conviction, not only of Jennifer, but later of her husband as well.
Well,
Sure.
just so you know, I didn't agree with that. I said these are not the right charges. I think
they are the right charges.
No.
That's what I meant to say. If I misspoke, I apologize.
No, you said I said that I think they're the wrong charges. I think that based on what we heard in the Miller hearings, I believe that the best thing the prosecutor should have done was charge them with child abuse. And I think as a result of that, I think this would be a slam dunk. So
Now, Rick, you seem pretty solid on your stance. Again, you were with us and we saw so much that was presented about these parents, and it's very disturbing. Can you elaborate on why you feel like these are the appropriate charges and why they should be held accountable?
Well, the wanton recklessness of their actions and omissions, I think, are overwhelming. I think that each and every step they took after they were notified of the child's problems, and they went to the school and they talked to the principal and the assistant principal, and they were put on notice. And what's Jennifer's text to her son? Next time, don't get caught, or words to that effect. I mean, the neglect rose to a level of recklessness, I think, that is beyond reproach. I think it's stunning behavior. Having a child with this deep of mental illness and then purchasing a gun for him and then teaching him how to use the gun, knowing and being aware of the consequences that might result, I think it's a foregone conclusion. I think that once the evidence is presented, that the jury will come back with a correct decision of guilty beyond a reasonable doubt.
I think it would be difficult to find a person who thinks that the parents' actions were wise or right, considering all that we know. But Terry, is it manslaughter? What are the members of the jury actually going to be forced to decide here?
Well, realistically, I think the job of the defense attorneys, Jennifer's going first. She's got a great defense attorney, Ms. Smith, and she's really going to have to connect with the jury and show them that these elements cannot be met. I mean, realistically, if you look at involuntary manslaughter, like you just mentioned, you know, how they treated the child and the mental things with the child abuse should have been the proper charge. But I'll take it a step further. If this was manslaughter based upon these actions, why not charge the people in the school who didn't check his backpack? And if you really look at what I've heard some of the questionnaires are about firearms and firearm ownership. So is this really about manslaughter, or is this about don't bring guns to school? I mean, if this action would have happened with a bomb as opposed to a gun, would these same charges be coming forth?
But considering that this is a child who said out of his own mouth that he was begging for some kind of help with his mental illness, and his mother in turn takes him to a gun range, you still feel that way?
Yeah, because what did she do? She neglected the child, right? He's begging for help. He didn't get the help he needed. The parent has a duty to give them the mental help, and the parent didn't do that. That's child abuse.
Well, I agree. It is neglect, but the level of neglect, I think, rises to criminal neglect. And criminal neglect is wanton recklessness, and wanton recklessness is involuntary manslaughter when a death wasn't intended specifically.
But they have to have knowledge. The parents would have to have knowledge.
Awareness. They have to have awareness that the act or the failure to act will result in the consequences of a death.
You know, something that I keep thinking about that we heard the shooter himself say at his sentencing hearing, he said that it was not his parents' fault, that they could not have stopped him. Could that statement in court at his sentencing be used as evidence? Does it matter if he thinks it's their fault, or does it matter whether the prosecutor and the evidence shows it was?
Well, remember the other things that this kid thought,
Sure.
you know, how misplaced his thought patterns were, and his mental illness, how deep it was. So I think that saying that his parents weren't at fault is to be, you know, taken cum grano salis.
Do you think the parents' attorneys will try to use that, though? Can they use that? Is that
sure
admissible?
They can. Well, it'd be hearsay. I don't know if that would be admissible. There'd have to be a reason to exclude, a reason to admit the excludable hearsay. And if there is, if the defense attorney takes that position and can admit that evidence, I think, you know, it'll be used. Yeah, anything that can be used will be used by the defense attorneys.
Yeah. Lastly, I want to ask you all, we've known that they've been trying to get certain pieces of evidence removed from their trials, but based off of what we've already heard that is really so damaging, does it make much of a difference?
Well, that's why the next few days with jury selection is going to be very important. You want a jury that is going to have everything filtered through the court. And you want someone that has no, I don't want to say outside knowledge, but they are not watching CBS 62 to, you know, find out what's truly going on. They're like really removed. Those are the people you want in. If you get somebody who says, basically, I'm just going to lie to get on jury duty because I want to get these people locked up, that's what we're trying to get rid of.
All right. Thank you so much for joining us, both of you. This is going to be a process. We know it may be weeks, possibly even months before it's all wrapped. We will be following it all. Terry Johnson and Rick Convertino.